Hello and welcome to ACCA Masters. My name is Ather Aziz and it's our first lecture on the paper F4 or law. Let's start with the definition of law. Law is a set of rules which is decided by the authority of any particular place, and the basic purpose of law is to keep the peace and security of society. Now if I talk about the types of law, then the major two types of law are civil law and criminal law. Let's start with the civil law. Here in this case, the offender and the victim both are individuals. The victim look for the compensation for his loss instead of any kind of punishment, and based on the evidences, judge decides either the offender is liable to pay the compensation or damages to victim or not. In civil law, we have two types of courts, county court and high court. While if I talk about criminal law, the offense is considered against the state. So the state enforces law here. Here in this case, the offender is punished for his act, and the jury decides either the person or the offender is guilty or not. Here we have two types of courts, magistrate court and crown court. Now we know that magistrate court and crown court are the part of criminal courts. Magistrate court, if I talk about it, then it usually deals with summary cases where the maximum fine that can be imposed by a court is not more than £5,000, and the maximum imprisonment that can be announced is no more than 6 months. Here the decision is taken by magistrate. Now if I talk about crown court, then it deals with usually more serious kind of offenses, and here the decision is made by jury and the punishment is decided by a judge. Now here if I talk about this word jury, then these are the group of independent civil people who evaluate the facts and evidences of the case to reach at a conclusion that either the person is guilty or not. Now after reaching to any conclusion, if they think the person is guilty, then the judge can decide that person's sentence or punishment. Okay, so some cases are called either way cases, for example theft, drugs, etc., and these cases can go either to magistrate court or in the county court, which is the part of civil court. Now if an offender of criminal case thinks that a legal mistake has been made in the decision by judge, then he can appeal this decision to upper court. Let's say a person want to appeal the decision of magistrate court, then he will go to crown court first. Now this crown court will also make a decision based on available evidences. Now if he again think that this decision is wrong, then he can go to court of appeal. Here again any decision will be made based on facts and evidences. Now again if he think that decision is wrong, then he can appeal this decision to Supreme Court, and the decision of Supreme Court can be appealed in European Court of Justice, but in specific cases. Crown court cases also follows the same procedure. For example, if you lost a decision at crown court, you can make an appeal to Court of Appeal, after which you can make an appeal to Supreme Court, and then finally to European Court of Justice, but in specific cases. Now if I talk about county court and high court, which are the part of civil courts, then we can say that county court usually hears small and fast cases. For example, if the claim is below than £10,000 and no need to attend. And in the case of fast track cases, the range is between £10,000 to £25,000 and it held in court in one day. Now let's say the amount of claim is more than £25,000, then it will be heard in High Court. High Court usually hear large and complex cases. Same like criminal courts, a defendant can also make appeal to higher court in case if he think that the court makes some legal mistake. And in both cases, for example in the case of county court and in the case of high court, the appeal can be made to the following courts. First of all, it will go to Court of Appeal. Then the person re-appeal it into Supreme Court, and after which the person can re-appeal to European Court of Justice. And in some rare circumstances, one can directly appeal to Supreme Court from High Court instead of going to Court of Appeal. Let's talk about European Court of Justice. It is the Supreme Court of those European states which have signed up European Convention of Human Rights. Here, any individual who alleges that their human rights have been violated can bring an action against those who are responsible. It overrules the Supreme Court decisions only in respect to European Convention law matters. As a law student, you should also know some legal concepts. First, talk about plea agreements, which are also known as plea bargaining. Okay, so here the defendant admit himself or herself that he is guilty for specific crime in the favor of lesser punishment. Let's say we have three types of crimes here. First degree crime, second degree crime, and third degree crime. Let's say the punishment for first degree crime is 10 to 15 years, and for second degree crime is from 5 to 10 years, and for third degree crime is, let's say, 3 to 5 years as an example. Now the person who did crime either fall in this category or in this category. Now I am assuming he did first degree crime. According to plea agreement, he admit himself that he is guilty for specific crime, and as a favor he asks for lesser punishment. Then the judge may give him less punishment, let's say of 5 to 10 years instead of 10 to 15 years, because it saves the time and money of government, because no trial conducted in this case. But if after the conduction of trial he proved guilty in the light of available evidences, then he cannot ask for any lesser punishment or for any favor. So it was the concept of plea agreement or plea bargaining. You will also usually hear these words prosecutor and lawyer. Now let's see what is the major difference between both of them. Both of them are lawyers, but prosecutor represents the interest of state or act as a lawyer on the behalf of state. and he tries to prove in court that the person is guilty, whereas a lawyer works for the individual who is being charged with a crime. We have another concept of arbitration. Here in the case of arbitration, both the person who sues and the person who defends forego their right to go to court. As they foregoing their right to go to court, they may decide to settle this dispute outside the courts. For this reason, both of them may hire an independent arbitrator who tries to settle the dispute of both of them. So it is the concept of arbitration. So that's all for this video. See you in next lecture.